Hello, my name is Kelly Curry, and today I'm here to speak to you about equal opportunity in employment under the law in America. So specifically, I want to talk about the history of employment inequities in America, which namely affected women and minorities. And then I want to talk to you about how the same legislation that was created to help these people progress forward is now working against a new group of people today in the year 2016. So I'll start with talking to you about the Civil Rights Act of 1964, which you may know was legislation that was drafted by President John F. Kennedy and passed through Congress and into law under President Lyndon B. Johnson in 1964. So the overall goal of this legislation was to create equal rights for people in America, and within this legislation were title laws. So Title VII of the Civil Rights Act of 1964 specifically addressed equal opportunity in employment, and it sought out to abolish the employer's ability to discriminate against employees on the basis of sex, race, national origin, gender, etc. So before Title VII of the Civil Rights Act of 1964, women and blacks were not given the same opportunity as white males in America within the scope of employment. So women traditionally were being paid much lower wages than white men, and they were generally working in fields that they could not advance forward in. And this was done because women at the time were seen generally as caretakers of the home, and that their main role in society was to reproduce and take care of the family. So there was a fear in America that if women began to work at the same capacity as men, we would completely destroy femininity as we know it. So during World War II, when the men went overseas to fight the war, women were asked to retain their jobs. And this was a huge advancement for women because they were now working at the same capacity as men. However, when men came back from war, their employees fired them and they returned the jobs to the men. So this was a huge discrimination in employment based on gender. As far as African Americans in America go, they've been discriminated against in employment since the time of slavery. And generally, up until 1964, African Americans were offered employment in the fields as tenant farmers or in the homes of white males as domestic servants. So these opportunities for employment were either low paying or no paying. And the skills that they were gaining in these jobs were not going to help them progress forward in employment. So at the time, public institutions in America were segregated, and that included schools. So the schoolings for African Americans in America were not providing the same education and skill set that whites were getting in America. So this was, again, functioning against the African American being able to advance forward. After Brown versus Board of Education and the desegregation of public institutions in America, African Americans did begin to advance forward. However, it created a ton of white backlash. So white males in America were now scared that their jobs were going to be unfairly given to African Americans based solely on race. And they saw Title VII of the Civil Rights Act of 1964 actually as reverse discrimination. So in some cases, white males actually challenged legally that Title VII was unethical on the grounds that it didn't consider white as a race. But the Supreme Court upheld its standards on the grounds that certain groups, such as minorities and women, were systematically denied employment opportunities because of the way that employers were able to hire or fire based on race. So today, there is a need to reanalyze the language within Title VII of the Civil Rights Act of 1964 because we need to ensure that all people are given the same protection under the law and equal opportunity in employment. And when this legislation was drafted in the 1960s, the word sex was loosely defined to really include male or female. But today, the spectrum of gender identity has really expanded, and we now have a group known as the LGBT community. So that includes lesbians, gays, bisexuals, and transgender. And today, only 21 states actually provide statutory protections for LGBT people, and the courts are utilizing a number of limits to really distinguish claims based on either sex or sexual orientation. We have to advocate for change. The law cannot function against a person's gender identity. Employers should not be able to discriminate on the grounds of sexuality. There has been a case where the court recognized a claim under Title VII where a female failed to present herself in a manner that was deemed sufficiently feminine. So what we're doing right now is we are defining femininity in the same way that it was prior to Title VII being passed in 1964. So this proves that there's limitations to the legislation of Title VII, and we must advocate for a reanalysis of the language of this legislation. The outward manifestation of gender should not be considered by employers, but rather the individual's workability. By allowing employers to discriminate on the basis of gender, we're taking steps backwards. We are mirroring the inequities in employment experienced by African Americans and women before 1964. We have to deconstruct gender. We have to combat sex stereotypes that employers are able to uphold today. Although the legislation does protect many individuals in their right to employment, the LGBT community is not protected because the court has drawn a line between discrimination based on sex and discrimination based on sexual orientation. We need to ask ourselves, what is sex? What is sexual orientation? Why are these two things separate under Title VII of the Civil Rights Act of 1964? Do we need to reconstruct the language to either include more wording that can protect the LGBT community, or do we need to take out wording so that people are not being oppressed? Until we can change the language in Title VII of the Civil Rights Act of 1964 to protect the LGBT community, we are supporting the oppression of a major group in America who are ultimately going to fall behind in gaining the education and skill set to advance in employment. This is mirroring the way that African Americans and women were oppressed prior to 1964.